morning. It is a pleasure for me to give a warm welcome to all the participants to this conference, to those who are sitting here at the desk, and also the members of the audience. And I have to say that I do have great expectations from the meeting this morning, and I hope that you share with me the expectations about learning and about understanding a topic which is, I would say, particularly important. Let me say, before introducing the guest speakers, let me just say a few words of introduction and perhaps try to explain why I have so high expectations from the program today. Now, indeed, it is, I would say, quite an ambitious program, and we've tried to squeeze into a short period of time, just a few hours, topics that are by themselves very large and very intriguing, but I think that we can be satisfied if at least we focus the issues and we try to frame some possible answers to the issues. Of course, we don't have the ambition of having a final answer to all the problems that we are going to deal with. I said it is an ambitious program, and as you well know, because you're here, we are going to study and discuss a legal phenomenon which is per se quite common to those who are engaged in comparative legal research. The legal phenomenon being circulation of models and legal transplants. So from this point of view, I would say nothing new. Those who are engaged in comparative legal research have been practicing research in circulation of models and legal transplants for a very long time. So, of course, it is what circulation of what models and what kind of legal transplants. And let me start from my remarks from the question that is at the end of the title. What prospect for a sustainable legal pluralism in Europe? Although, of course, we are going to focus on two, what I like to call geo-legal areas, like Europe and Northern Africa and the Middle East. We are interested to focus on the interaction between the two of them, knowing that, and this is a typical remark for anybody who studies social society, is a social phenomenon, that the two geo-legal areas are not at a standstill. They move, they evolve, they transform, and in fact, they're quite dynamic. So there are changes in Europe, and there are changes also in Northern Africa and the Middle East. Although, of course, we always like to describe them as having some main features which characterize them, which have done so historically. And we like to think, because we always liked easy things, we like to think that they are still the features of those systems, whereas things may change. So we have here two experts, and I really understand that they are, from what they wrote and from the conversations that we had, who can give us a proper image of one geo-legal area, the Northern Africa and the Middle East, and Europe, in particular one European country, which is the United Kingdom, and try to see both from the point of view of what they are, what they have been, but how they are facing the challenges of interaction. And we are going to have then a reconstruction of the system of personal laws in Northern Africa and in the Middle East, knowing that personal laws may be shaped differently in different countries, in Northern Africa and in the Middle East, and trying to see also to what extent two concepts which are quite typical of the European scenario, like equality, which is strongly and intimately connected with citizenship, are framed in those countries as well. And at the same time, when then going to move and see how one particular issue, Sharia family law, is dealt with in a system like the United Kingdom, which for a number of reasons does have a record of pluralism and tolerance, and is going to show to what extent pluralism and tolerance do raise a number of questions, not only when it comes to the outcome of the case law or arbitration courts, but also out of the very existence of arbitration courts that are meant to enforce Sharia law. So irrespective of the case law, is the very existence of such courts which does create problems, as it has created problems elsewhere. So, so we have two building blocks, and then of course we are going to see how a discipline, a scientific discipline other than the law or comparative law, deals with such issues. And in a few words, I'll say why. And this is the perspective of legal anthropology. And this is particularly important because we deal with cultural transformations, we deal with cultural challenges that do create problems of understanding which go beyond the capacity of the law to frame problems and to suggest solutions. Now, let me just say that under the label of circulation of models and legal transplants, we're dealing here with the interaction between different conceptions of the law, different conceptions of the role of individuals and groups in a polity, different understanding of the relationship between law and religion. And I would go as far as saying that we have here to deal with with features of a pre-modern legal setting, at least in Europe, and constitutional modernization. Why is anthropology important? Because we are now facing a situation in which such cultures have existed in the Euro-Mediterranean area for centuries. They have known each other for centuries. They have also practiced each other for centuries. But now it seems that they are at a crucial point in which they have to decide, so to speak, how to frame their mutual relationship within a framework of legal pluralism in Europe. When I talk about interaction between legal cultures, I mean interaction between identities. And this is why I think that we need the contribution of legal anthropology. Now, from the legal point of view, identity is a newcomer, or if you like, the law, if you like, the law is a newcomer in the field of research on the issues related to identity. And so we have to learn how to deal with identity. Identity has become a legal category, I would say quite recently, and all the legal categories referring to identity have come at the same time. Identity of individuals, identity of groups, even identity of polities, if you think that even in positive law, the protection of national identity has become one of the limits, if you like, or one of the distinguishing features of the European Union. Not that identity has not been present in the Western legal culture, but of course it was framed differently. And I still believe, for instance, that a certain individual identity is a way towards emancipation, at least in our culture. And collective identity is a way towards protection. And perhaps individuals now need more protection than assertion, more protection than emancipation. The quest for protection within the group seems to be as strong as the quest for individual emancipation. We're talking of legal pluralism. Of course, what kind of legal pluralism? Now, I think that we cannot ignore the basic teaching of John Griffith in dealing with legal pluralism. And he said, by legal pluralism, I mean the presence in the social field of more than one legal order. And he described legal pluralism in a weak and in a strong sense. In a weak sense, and he specified that the legal system is pluralistic when the sovereign implicitly commands different bodies of law for different groups of the population, which may be the case now, and certainly is the case of Northern Africa and in the Middle East, where, including Israel, where the Ottoman millet system, which is exactly what Griffith described as weak pluralism, weak legal pluralism, exists. Now, it is indeed a hierarchical architecture. The principle of the dhimmi, of course, I think you will talk about it, of protected religious minorities, the populations of the book, the monotheistic religious groups, which are allowed with some degree of tolerance to self-govern themselves, to have, apply, enforce, elaborate, develop their own rules, as long as they accept the Ottoman rule or the Muslim rule, if you like. So this is also a tradition of weak legal pluralism in Northern Africa and in the Middle East. What is happening now in the constitution making in Northern Africa and in the Middle East when it comes to the Sharia protection clause, when it comes to protection of minorities, when it comes to acknowledgement of legal pluralism? Does it have a constitutional status, or is it something which is rooted in legal culture, in legal practice, which perhaps doesn't even need to be constitutionally mentioned? This perhaps is something that we request and not other cultures. In Europe, we have elaborated a more inclusive and balanced understanding of equality, which has been perhaps more recently developed in order to accommodate the rights of minorities, language, religious, cultural, national, and the right to one's own diverse identity, as well as to restore structural social weaknesses inherited from the past. And I refer in particular to the role of women in society and in the legal system, to the extent of allowing for legitimate affirmative action by the lawmaker. So Europe is perceived, at least is perceived by Europeans, as tolerant, as plural, as able to accommodate diversities. And let me add one thing that Griffith wrote, which I think is quite relevant, when he said that legal pluralism is justified as a technique of governance on pragmatic ground. I think this is very interesting and very challenging, as I wonder to what extent an option towards legal pluralism, such as the one that is practiced with so many difficulties in the United Kingdom, may be regarded as not so much as a matter of justice, of abstract justice, but as a technique of governance on pragmatic ground. So we shall see how that develops. Now, if comparative legal reasoning, comparative legal research has to tackle with such issues and to take into consideration the contribution of legal anthropology, then comparative legal research requires to develop and go further with its own methodological approaches. So how do we have such a methodological approach? Are we able to incorporate the hints coming from legal anthropology? Aren't we sort of enchained by sort of self-rewarding understanding about our own tolerance and liberalism, even before meeting the challenges which we are going to have to face today. So the methodological refinement in any discipline is particularly necessary, and we are going to have a contribution in this direction as well. So let me, at this stage, introduce the speakers who will, and as I said, they are experts in the sense that we have great expectations because of the record of their previous research and because of the very fact that they accepted to be here. Now, the first speaker will be Gianpaolo Parolin, who is a professor at the American University in Cairo, and he is also a professor at the State University in Cairo, which means that he teaches in English at the American University and in Arabic at the State University, and I'm absolutely impressed by having a colleague who can teach also in Arabic in Cairo. A book came out a few days ago by, I think it's Oxford University Press, edited by Eva Pföstel and Bill Kimlicka, on protection of minorities in the Middle East. And I think it's in footnote number 4 or 5, your book on citizenship is quoted. And so I say,
I didn't know that. I'm very happy to hear.
Okay, so I'll show you. So
I hope it's a good footnote.
Well, it says C. Parolin,
okay.
So it's
good enough.
It's good enough, yes, it's good enough. So I was, of course, very delighted when I read the book because I said, wow, well, footnote number 4 is coming to Trento next week. Of course, more than footnote number 5. And then we have another colleague from the University of Leiden, Machtel Zee, who has written a very, very fine paper on the experience of Sharia courts, as arbitration courts in the United Kingdom. And she has very clearly spelled out advantages, disadvantages, consistencies, inconsistencies about having such experiences, which is quite controversial, also because the BBC had a television broadcasting service which had some interviews with those who lived this experience, and as a consequence of this, and you can still watch it on TV, and as a consequence of this, it became a big issue of national debate. And so we are going to have this particular experience taken care of. Then we have Maria Bartolomei, who is a researcher on legal anthropology, who has an interesting experience of research in the field, in Africa, in India, and she published in particular about the role of traditional courts, and to some extent you can frame traditional and religious courts in a way which is, of course, not, which does not make uniform what is different, but does create the same kind of problems for state judicial authorities. And Roberto Scarciglia from the University of Trieste, who is one of the leading scholars in comparative methodology, will, as I suggested, try to incorporate the challenges of the topics and also thanks to the interdisciplinary contributions within a persuasive methodological approach for comparative legal research. Now, between the first two and the second two, I hope we'll have a short break, and perhaps we'll deserve it, which can be coffee break or tea break or apple juice break, whatever you feel like, to go to some cafes around or to the machine downstairs to take. It's not an organized coffee break. It's a tolerant and free coffee break, free from all points of view. And then we'll have, I suppose, after lunch, we have two more contributions coming by two colleagues in Trento, who will bring their own contribution, both in terms of research experience and insightful understanding. One from Laura Baccaglini, will be on the appropriateness of the use of arbitration law in matters of family affairs, something which would not be feasible in continental Europe, which is feasible, and in fact it is done in the UK, as it was also experienced in Canada. But this, of course, does create some problems, because the field of private law is the field in which the autonomy of individuals can settle the issues, whereas in the field of state judicial authorities, of course, you cannot possess the ways for resolving disputes. And then Davide Strazzari, who has, again, a research experience in the field of migration law and rights of migrants, in particular when it comes to the interaction between different legal traditions, and in particular within subnational legal systems, which in a way already create problems of legal pluralism with regard, although it is a different legal pluralism, with regard to the state where they operate. So we are going to have from them a further contribution, but also some comments on the main papers which have been presented, which will have been presented. And then, of course, we're going to have a free discussion among all those who will have survived until the end of this. So thank you very much for your patience in listening to me. Of course, let me just say that this seminar is part of a wider research on jurisdiction and pluralism. Legal pluralism is one of the faces of the impact of pluralisms on jurisdiction, but very much challenging indeed. In fact, we have already, the first seminar here in Trento was on legal pluralism and personal laws in Asia. Then we had another one in Northern America and Northern Europe. And now we have this one on the Middle East and Northern Africa. So we're trying to map legal pluralism, the challenges that it creates. And the very last remark is that, as it happens on so many issues in our contemporary times, all the problems come to invest the judicial power, the jurisdiction in the strict sense. It is as if the political lawmaker is unable to settle a number of issues and prefers to have not general and abstract solutions, but a sort of piecemeal patchwork, if you like, a mosaic of solutions for individual cases. And this perhaps is also one of the characterizing features of our time, if not of our legal system. So having said that, and I will ask now Gianpaolo Parolin to take the floor and give us the first paper, which has a title. No, it does not have a title. And so we have a titleless presentation.
Thank you very much. Thank you for the introduction. Thank you for the invitation to be here and participating in this conversation. Thank you for the students of my law and religion classes and my Islamic law classes for being here, and all the other who decided to participate in our conversation with us today. Now I have another sign that I'm getting old. Not only my hair is turning gray, well, it's pretty much all gray, but now I'm also footnoted, so I'm footnote number 4. Okay, so as my students know, my obsession with transformation and legal transformation is deep-rooted. So I will pick up on the comment by Roberto at the beginning, and this is actually the lens that I will use to analyze the system of jurisdictions and applicable law in the southern shore of the Mediterranean. Before doing that, so I do not have a paper per se, but I have a fat 148 research report, which I was commissioned to be the scientific expert for, within the Euromed project last year, which I think is fairly interesting because it signals the fact that the European Commission is, is realizing finally that a dialogue with the legal systems of the southern shore of the Mediterranean is important and needs to be a strong part of the Euromed relations. This particular research report and project was on the resolution of cross-border family conflicts, which means strongly in the area of family law. However, today I would like, I think in order to frame the problem correctly, we need to broaden the scope beyond family law. The research report itself will be available shortly. It's in its draft stage at present because it needs to be approved by Commission first. But it will be available online. So this is a disclaimer. The way these reports are conducted at the Euromed level is that the scientific experts prepares a questionnaire, which is then sent to the national teams, which are usually people selected by the ministries and work within the ministry. They answer the questionnaire, and the job of the expert is actually to put together these answers and offer like a framework to actually look at them comparatively. So you will see that, sometimes I try to fight with the national teams, like, this thing that you're telling me is not actually true or is not accurate. And sometimes my battle was successful, sometimes it wasn't. So the disclaimer is not everything that is in the report is my authorship. So anyway, this is the fun of, international enterprises. Okay, so the first point that I would like to cover with you is that in order to understand the actual configuration of the system of jurisdictions and applicable law in the region is to push our time clock backwards a bit. And of course, the appeal of the concept that we see that feature mainly in the title, citizenship and equality, I would argue that it's not necessarily an ideological appeal per se, but rather an instrument towards reaching a configuration of the state that was in line with the French model at the time. So we're looking fundamentally at the 19th century, when the inspiration for the reforms had its roots not in the appeal of a foreign model, but rather in the desire of reorganizing the empire, and here the focus is mainly on the Ottoman Empire, of course, along lines of efficiency. So I think that is the key word, efficiency. And the model was the French model, and the authorities in Istanbul saw as the key to efficiency equality. Equality because that meant a fuller control over the subjects. So there's no romantic view of equality at the outset of the Tanzimat. So, when we, I presented it also in class, the importance of the Gulkhane rescript so the rescript of the Garden of the Roses, it's very romantic, equality for all subjects, and then the Khatti Humayun of 1856. Sure, equality, very important. However, the objective was actually to assert the power and the jurisdiction of the Istanbul authorities over all subjects on Ottoman soil. This, of course, ends in 1869 with the law on Ottoman citizenship, which somehow seals this reform drive. However, the other side to that is that there are areas in which full equality was not considered to be desirable. And they were somehow left outside the scope. And that's namely what has become known as personal status. Now, before again, the 1800s, there was no such thing as personal status. Now we have to deal over and over with this idea that Islam and Islamic law is all about personal status. There's no such thing that distinguishes personal status from other areas of Islamic law. So much so that if you look at any fiqh treatise from the past, there is no such distinction as personal law or other parts, and it's on a par. I mean, marriage regulations are on a par with regulations on ritual ablutions or inheritance, or well, inheritance is now considered part of the personal status, but contracts, sales, you name it. So there's no, I mean, the idea that personal status is a cornerstone of Islam, it's an important part of Islamic identity, is actually the byproduct of this transformation of the legal system that was initiated in the early 1800s in Istanbul. So as I said, this idea of introducing equality did not reach all the areas of the system. So for instance, when Istanbul wanted to introduce the civil code, they opted for the Swiss civil code. And the reason for that was quite simple. It wasn't because Swiss do it better. It was rather because the Swiss code didn't have in it the part of family law that they wanted to leave outside. So it was merely, you know, a practical consideration. So it was also deliberate to live areas, to somehow start building this separate area under the, so let me reverse this sentence. So the idea was Istanbul was very much interested in extending its lawmaking powers over areas that were previously covered by Islamic law and within the jurisdiction of the Qadi. And it couldn't do that on the entire area of fiqh, so it selectively chose areas. And those areas were mainly contracts and obligations and commercial law, and everything that had an immediate relevance for the port. And then it left to the side the issues of family law, which were considered to be less relevant for the reform drive. Incidentally, this is actually what colonial powers did in many other respects. So they were very much interested into regulating other aspects of the law, but they were very happy with leaving, you know, family law, inheritance, and all of that to the regulation of, you know, traditional or religious laws. Another element that I think we need to keep in mind when we look at this issue is that the idea of an autonomous jurisdiction and an individual law is somehow a building block of the Islamic conception of religious freedom. So when I say Islamic here, I refer to the ideal representation of scholars, right? So what Muslim scholars saw as Islamic, right? And in that representation, religious freedom fundamentally meant that each community had the right to have its own laws and its own jurisdiction. This has also quite strong textual basis for that, in as far as there's even Quranic verses that regulate this, especially in the Surah Al-Ma'idah, the 5th. So I think it should come to no surprise that migrants consider part of of any definition of religious freedom, the freedom to have your own law and your own jurisdiction, because that's what they experience in their home countries. So the question would be, so yes, there is a strong, let's say, religious basis for the articulation of religious pluralism, both in terms of jurisdiction and applicable laws. Then the question would be, what are the sources for that? I mean, yes, there's a textual basis, which I just mentioned, but I think we also need to consider the fact that the regulation of these multiple jurisdictions and multiple applicable laws is usually regulated under the heading of international law. Now, it's not called international law in fiqh treatises, of course. It's usually falls under the label of jihad, but under the label of jihad is, of course, the main regulations of international law. And I think that's pretty much accurate, because it shows us how scholars would look at the issue, right? So it was the idea that there are nations, and hence also the use of the term millet in the Ottoman context, even though the millet system goes way before that, even before Islam, some say. So the idea that you have nations that live in your territory and are awarded the possibility to actually legislate and adjudicate according to their own laws is framed under the idea of international law, which also means that there's very little interference on the actual content of the applicable law, but also on the selection of judges that are called to adjudicate on these issues. And I think this will come out quite clearly also when we look at the contemporary arrangements on the southern shore. Part of that is also due to the fact, I mean, part of this, let's say, framing of the issue in terms of international law is also due to the fact that many of these privileges to keep their own jurisdictions applicable laws descended from international agreements that were entered into and became part of the regulation of scholars. So we have this very, let's say, composite outlook of parts regulated by scholars and parts based on treaty privileges that were signed by representatives of non-Muslim communities and the Muslim ruler. That system was became even more complex when interactions between European powers and the Ottoman systems and the Ottoman Empire started regulating their relationships on the basis of treaties that were known as capitulations. So these capitulations introduced a further level, which was the possibility of the subjects of the European powers to be judged according to their own law by their own consular authorities. So to the already complex system of a multiplicity of jurisdiction applicable laws, you add this further level of these foreign laws and consular jurisdictions. And this is fundamentally true until the 20th century. I mean, the end of the capitulation structure is very recent. Now, somehow the transformation of that usually took the shape of mixed courts, that is, courts that were set up to adjudicate on cases in which foreigners and local subjects were involved. And on these mixed courts, the panel of judges were usually, of course, belonging to both, the European powers, the signatory European powers, and local subjects. This mixed courts played a very important role in the transformation of the legal system, because that's how they actually introduced, or at least they practiced, the operation of European codes into the developing legal systems, and then this experience was somehow transformed into civil codes that were applied by national courts when mixed courts were abolished. This system, which appears extremely pluralistic and extremely flexible, has its own challenges, because especially when we look at it from the perspective of both from the perspective of the Muslim community or Muslim communities and the perspective of non-Muslim communities, what we see is that this system empowers the authorities of these communities to decide what is the law that is applicable on all the subjects. And of course, this can raise issues and opposition. We have seen that very clearly already in the 1800s with the Armenian community. And actually part of the Ottoman reforms was precisely to somehow, quote-unquote, free the Armenian community from the long hand of their nobles and their, aristocratic elite that was somehow suffocating the Armenian community itself. But I mean, if you look at nowadays, the fact that, for instance, in the new Egyptian constitution, the church, the Coptic church, which was represented in which had a representative in the Constituent Assembly, has a new provision that guarantees its role as fundamentally the representative of Copts in Egypt, is very problematic and has been contested by the so-called movement of Copts of 38 that are the quote-unquote liberal Copts that, do not fundamentally agree with the church policy. And, not agreeing with the church policy, it's not just that, you don't agree on how your, the church money is spent. No, it means that the church has a say on whether you can get a divorce or not. And actually, the label Copts of 38 is precisely because they refer to the 1938 provisions on the options for divorce, which were severely curtailed by the previous Pope, Shenouda III, and so, I mean, why would you empower like the Coptic Church against the possible freedom of Copt? And that can be said at the same level for Muslims. And I think that this is also something that we need to keep in mind, that the major victims of this system is actually the religious freedom of Muslims, because when the state comes in and regulates the religious authority and the content of the applicable law is more on the Muslim communities than on other communities. So somehow this idea of this international law relations is maintained. So if you look at, for instance, at the appointment of judges and the decision on the content of the law that they apply, especially in the Levant, you see that the appointment of Muslim judges is decided by the state, whereas the appointment, for instance, of Christian judges is decided by Rome. The content of the law that Christian judges apply is decided in Rome. The content of the law that Muslim judges apply is decided in, either Amman or Beirut or wherever. So I think we also need to, to realize that the long hand of the state is usually more at the expenses of the majority Muslim communities rather than minorities. And minorities somehow retain this idea of being like a national subunit. If we think, for instance, which is also, again, very problematic because it's not like a political community, but it's rather a religious community. So, for instance, now, again, looking back at the early 20th century, the person who went to the Paris Peace Conference to negotiate the independence of Lebanon and actually the configuration of Lebanon as it is with the provinces of Trablus, Saida, and the Beqa Valley, it was the patriarch, the Maronite patriarch, Ilyas al-Harawi. It wasn't like a representative of the Maronite community, it was the patriarch, and very much is still the case that these religious authorities hold a very important position politically, which further somehow complicates the issue. Again, on these challenges, and again, this is like an example from Egypt, state courts try and, where there are state courts, try and somehow modify or tweak minority confessional laws, as in the case of Copts. They try and say, hey, the right to divorce is considered to be like a constitutional right. If the court, if the church refuses to divorce you, I will divorce you. I, state court, will divorce. I will divorce you. Of course, the next step is that since there is no civil marriage, then the Copt who's been divorced needs to go back to church to get into a new marriage. And the church says, no, I'm not going to marry you because from my perspective, you're still married. So the state institutions issue like an order to the court to marry someone, and the court just simply refuses. So you're in a stalemate because now you have the Copt who's divorced, but he cannot get married again because the court refuses, and there's no perspective whatsoever of having like a civil marriage in the near future, which is somehow a feature of most systems on the southern shore of the Mediterranean. So I propose classification into three possible combinations of the system of jurisdiction and applicable law on the southern shore. So the first model is what I call the Maghreb system of a single jurisdiction and a single applicable law. Here, a civil court has general jurisdiction over family matters and applies in all cases a codified, quote-unquote, civil law. This, of course, does not mean that the codified civil law cannot be inspired by religious precepts, quite the contrary, but is one law applied to all cases regardless of religious affiliation. And this is the system followed in Algeria and Tunisia. The second model is the Egyptian system of a single jurisdiction and multiple applicable laws, religious. Here, a civil court has a general jurisdiction over family matters, but applies, in different cases, different religious and/or foreign laws. the applicable law is determined on the basis of a complex set of rules defined as the internal and international conflict of laws system. This is a system followed in Egypt, of course, but Morocco follows a similar, if slightly different, one. In the Moroccan context, for instance, two different sections of the family court adjudicate on Jewish law if the parties are Moroccan Jews, or on the family code, that is the Mudawwanat al-Usra, if the parties are Moroccan non-Jews. The third model is the Mashraq system of multiple jurisdictions and multiple applicable laws. Here, a complex architecture of civil and religious courts apply. In different cases, different religious and/or foreign laws. Both jurisdiction and applicable laws are determined on the basis of a complex set of rules defined as the internal and internal conflict of laws system. This is the system followed in Jordan, Israel, Lebanon, and Palestine. What I think is fairly interesting here is that whereas Jordan and Palestine follow the system of a preeminence of one religious community over the other, which means that the default law in case of parties belonging to different communities is Islamic law. In Lebanon and Israel, the choice is different. And in that case, it's particularly interesting, the Lebanese choice, because it allows some freedom of choice to the parties. Because, for instance, in cases of family law, the law that regulates all the effects of marriage, including, filiation, conjugal relations, dissolution of marriage, and so forth, is based on the mode of celebration of marriage. So if the parties agree on a certain celebration of marriage, then they know that what they are entering into will also regulate all the other aspects of their conjugal life. Which is, of course, somehow it can happen only in Lebanon because of the structuring of and the birth of the country of Greater Lebanon as a mosaic of communities in which the idea was that there was no predominant community. Of course, at the outset of Lebanon, the agreement between Maronites and Druze was the cornerstone. But then that changed, also politically. But the idea was that, we couldn't have a one paramount default law, but we should have a different mode of solution of the conflict, which is still not the case, of course, in Jordan or Palestine. Syria was not did not participate for obvious reason to the report, but as far as I understand, that's also the case in Syria itself. So I got to the end of my 40 minutes. I think I will contribute also, especially on the issue of mediation and arbitration later on, because this was actually the idea that the European Commission was very much inclined towards. The idea was that there's very strong you said mutual relations at the beginning. You said interaction. So the experience in court interactions from the southern and the northern shore of the Mediterranean is quite the opposite. It's like mutual suspicion. Okay, so the idea that you can overcome this mutual suspicion by other forms of adjudication, and especially ADR, is something that the EU Commission is very much pushing for, which is funny because, internally within, the European legal systems tend not to push for that. But unfortunately, cross-border family conflicts, where family have members or parties from the northern and the southern shore, tend to be resolved very much on point of diplomacy and, you know, political bargain rather than on points of law. And so the idea of pushing towards that kind of area seems to be, again, on that same line. What I hope that my contribution to the report showed is that we need to also get to, I mean, the two systems need to get to know each other. Because if they don't, they will just keep invoking the exception of public policy, which is what we keep seeing over and over, to avoid either enforcement of foreign judgments or the application of a foreign law when the rules of conflicts of laws provide so. So I'll stop here, but I'm sure you're gonna, I'm gonna say something more. Thank you.
Very good. In fact, we are experiencing this kind of, it's very interesting that your remarks at the end, because one of the areas of research is exactly how rules of international private law are contributing to lessening the tensions between the different systems, and that's why I talk of mutuality. Also, because we have to realize, for instance, that institutions such as kafala have very different reactions in Europe, and there is an important decision of the European Court of Human Rights, according to which not acknowledging kafala as a functional equivalent of adoption is not a violation of the European Convention on Human Rights. So from this point of view, European states are not bound to host the kafala as it is now, because of a number of reasons, including the fact that kafala is not based on the acknowledgement of equal rights gender-wise, which of course raises the issue of the constitutional compatibility of legal pluralism, and this is why, in my introduction, I framed our reasoning within the category of weak legal pluralism, according to the description given by Griffith. Now, the preoccupation with women's rights is one of the issues which is at stake when it comes, in particular, to the experience in the United Kingdom. And I would ask Machtel now to give us her contribution.
Is on? Yes. Hi, everyone. My name is Machtel Zee. I'm a PhD candidate from Leiden University in the Netherlands, and I'm writing a dissertation on multiculturalism and secularism. And I've been studying Sharia councils in the United Kingdom as part of a broader case study. So behind my desk in Leiden, I read all I could on Sharia councils in the United Kingdom. And at the end, I still did not really feel secure that I knew enough. So I decided to pack my suitcase and go to London. And that's where I spoke to activists and lawyers and public prosecutors and professors. And in the end, I was lucky enough to actually go to 3 Sharia councils. One is the more well-known Muslim Arbitration Tribunal, where I spoke to Sheikh Siddiqui. I was not able to see any hearings there, but I did see hearings at the Birmingham Sharia Council and the London Sharia Council. But why are there Sharia councils in the United Kingdom? Because I'm sure they are here in Italy as well as they are in the Netherlands, but not public with websites where you have downloadable forms the way you have in the United Kingdom. And I believe that the reason why you do have these in the United Kingdom is because of the active espousal of the multicultural ideology, so a focus on the value of culture and the preservation of culture. And also the fact that the UK is a common law system which has large room for arbitration and mediation, and that legal jargon has provided the space for these Sharia councils. So Roberto already said that there was a large controversy on these councils, but even before the BBC Panorama show, there was a big ordeal on these legal institutions. So what happened in 2008, Archbishop Rowan Williams held a speech in which he said that it should be possible for Muslims to be able to choose jurisdictions when it comes to certain legal matters such as, and he mentioned financial law and marital law. He literally said it should be possible to contemplate a scheme in which individuals retain the liberty to choose the jurisdiction under which they will seek to resolve certain carefully specified matters. That didn't land very well, that speech. There was a lot of criticism. His colleagues at the Anglican Church called for his resignation. Gordon Brown said that it was unacceptable. David Cameron said that religious laws should always be subservient to state laws as there is equality before the law. And a few months later, he was helped by Lord Phillips. It was the highest judge in England at the time. When there was a new Supreme Court being installed in England, he was asked to be the presiding president, and now he has retired and is a professor at King's College. And I also spoke to him. But what did he say? That he didn't understand the controversy on Rowan Williams' speech because the scheme where people should have the possibility to choose already existed, he said. And it exists under the Arbitration Act of 2008. So what's the problem, he said. There's nothing new under the sun. In the United Kingdom, you have the possibility to have an extensive use of arbitration, and people are free to choose the rules that underlie the procedures. So whether these are Mexican civil law rules, or French, or Belgian, or even if you are a member of a tennis association, you can use your tennis association statutes. So that is what he decided was the status quo of religious law in England. So before I go in there, I want to clarify certain issues, and this is where I usually explain what Sharia law is, but I think you are a more well-introduced audience into this topic, so I'll just say that what I mean here in this debate is family laws, so not financial laws, because the British state has a distinct approach on that. They are actively espousing financial Sharia laws in the city. But why do people go to Sharia councils? And this is a very important point, because I believe that there is a lot of misunderstanding here. And in all literature and everything I've read, and I expect there will be some debate on this, is that at Sharia councils, people arbitrate or mediate. And that is unfortunately not the case, not at all. Because at arbitration and mediation, you always have two parties. Now, 99% of all Sharia council proceedings entail a one-party request, and that is a woman that wants a religious divorce. So independent from a civil marriage and a civil divorce, women go to Sharia councils and they have to pay a large sum of money, and they request a divorce. So how does this go? Well, a man under an Islamic marriage, so the nikah, the marriage contract, can simply pronounce the talaq, as you probably all know, and then he is divorced. A woman, on the other hand, has basically two options. There are more, but I will focus on the two most important ones. One is the ghul, and that's where a woman initiates divorce and the husband has to accept, and she will probably have to pay back the mahr, the bridal sum. But at these Sharia councils, usually the husband is absent, refuses to cooperate, is missing because he went back to his country of origin, or doesn't want to appear in front of the council. So what mostly these councils do is pronounce the fasq, and that's where an Islamic judge or a qadi independently pronounces a divorce, and a woman needs to be able to specify why. She cannot just say, I fell in love with someone else, or I'm tired. No, there have to be certain Islamic grounds, and for instance, one is when there is a sexual defect, or when the husband has been missing for a longer period of time, but mostly it will be violence. So in these hearings where I've been, you see women coming in one after another, and some are well integrated and speak perfect English and wear makeup, and some will be wearing scarves, or be crying, or will be fierce. There's a large difference between these women, but what they all say is, he beat me, he abused me, and I need to get out. And depending on the Sharia council where this woman goes, for instance, the Birmingham one is quite liberal. You will be done in a few hours, and then you'll be granted a divorce, but the London one is notorious for its lengthy procedures, and they will drag it on for years. And the judge, one of the judges I interviewed, actually said, marriage is sacred, so we will not break the marriage. We will always steer for reconciliation. And in case of violence, of course, this is very, very dangerous, not only for the woman, but also for the children who are involved. If a woman is still religiously married and not civilly divorced, sometimes there's not a civil marriage at all, and there's only a religious divorce, religious marriage, excuse me. We call that a status of marital captivity. That means that a woman retains married against her will, and in worst case scenario, she will be made sexually available, which is a euphemism for rape. The children will be held detained by the husband. She will be blackmailed and extorted for large sums of money. And in the eyes of the community, she will never be truly free. And this is a situation that women want to end, and that's why they go to these Sharia councils, because they want to end the status of marital captivity. And again, this is 99% of all proceedings at these Sharia councils. The third question is, how are these council rulings being enforced by English courts? Lord Phillips said, under the Arbitration Act, this has long been the case, but considering that the jargon of arbitration and mediation is used, but that is in practice not the case, the answer is not at all. Sharia council rulings are not enforced by English courts. Even more clearly, what's his name? I think Professor Bowen actually researched this, and there has never been one instance when a Sharia court ruling was checked by a secular judge. Now, that doesn't mean that English judges are never confronted with Sharia. For instance, if there are, let's say, foreign contracts with Saudis, then the content of Sharia law can be tested by English judges, but the Sharia Council rulings as they are manifest in England have never been checked by any judge. So, Phillips was wrong. I cannot emphasize this enough. So, then I started to study the arguments. Why do these proponents, so for instance, Lord Phillips or Archbishop Williams, why are they proponents for Sharia councils? And I call them proponents, but they will not call themselves proponents, because people will never say, I want more Sharia councils in the UK, but they will be slightly vague and emphasizing the positive aspects, and never commit themselves to the conclusion that that means that more Sharia councils need to be made available. But nonetheless, what are the arguments used pro-Sharia councils? So the first one is that there is a communal need for these councils, and in fact that's the point of departure in any debate. People will say Muslims want these councils, and who are we to deny them that possibility? The second one is that there is no conflict between Islamic and secular principles. I will come back to this one later. The third one, and that is the most interesting one for the legal focus in this paper, is that the idea that if you are not able to choose jurisdictions, this constitutes inequality. Why? Judge Phillips said, well, Muslims have a dual identity. They are both Muslim and citizens. That makes them different and unequal from British citizens, and therefore this inequality needs to be remedied by the possibility of going to your own courts. Fourthly, not to worry the secular principles as brought forward by the English state. They override concerns regarding religious discriminatory practices. And fifthly, always present, is that there are also ecclesiastical and Jewish courts. and it will be unfair and unequal to deny Muslims the possibility of their own jurisdictions as well. So, in short, the proponents, and I list here two, but there are also more in academia, is that it is just plain morally and principally wrong not to grant Muslims judicial autonomy, at least to a certain extent. And I think there are more arguments, such as Sharia law is very complex, and we cannot bring it back to one core area of law, but I think that these are the most important ones that keep coming up. So that's when I started to study the reactions, and I interviewed many activists and lawyers and the sorts, and this is what they told me on the communal need. They said, what communal need? There simply is not a sense where the community is demanding religious laws. In fact, 65% of British Muslims actively do not want to live under Sharia laws. They emigrated from an Islamic country to the United Kingdom to live under secular laws, not to be confronted with Sharia laws again. And Pragna Patel, who is an award-winning activist of the Southall Black Sisters, said, religion is a private thing, and we do not want religion to be institutionalized in the form of legal services, because that's when that's when rights are violated. And British Muslims for a Secular Democracy said, there have been no calls by ordinary Muslim citizens asking for Sharia councils. I mean, of course, there are religious leaders that occasionally say we should have more recognition or accommodation of Sharia councils, but ordinary Muslim citizens will not come forward and ask for Sharia councils. The Dutch-Egyptian writer said that if you want to help Muslims, help the right group, and by that she meant the group that actively does not want to live under Sharia laws and runs the risk of being peer pressured into a legal system they are actively trying to avoid. So that on the communal need, but what if a majority did exist, or what if there was a minority? Should we allow those minority or majority to voluntarily use Sharia councils? And that's when I thought, well, what does it mean? Oh no, sorry, I skipped one. Oh right, there's no conflict between Islamic and secular principles. I don't know if you're familiar with the Refa case. It's a very famous case. It was the Refa party, the welfare party in Turkey, and it was going to be a big party. They had, in the polls, they were going to be one of the biggest parties, and the party said that if we become the biggest one, we will want legal pluralism in Turkey, and they meant we want to have Sharia law in Turkey, and the Turkish constitution bans parties that want to breach the secularist principle that is manifested in their constitution. So the Constitutional Court banned this party, and then the party appealed for the European Court of Human Rights. And the European Court of Human Rights said, it is difficult to declare one's respect for democracy and human rights while at the same time supporting a regime based on Sharia. Well, this is, of course, a very fierce yet clear conclusion. And they said that, well, especially with regard to criminal laws and personal laws regarding women or homosexuals or non-believers, you cannot reconcile democracy and freedom and liberty with Sharia laws. And again, it is on the family law aspect here, because religion, in this sense, in family law, is always used to perpetuate a collective identity. So, let's say a secular legal system does not aim to perpetuate a collective identity. Religious law, on the other hand, does have a very special role for women, because women as childbearers and mothers are expected to hand through the collective religious identity for generation upon generation and generation. And that is the main difference with secular laws. So in Jewish law as well, but in Islamic law, where the focus is on now, there are the rules for women are much more difficult than for men. So men can simply pronounce the talaq and he's divorced. A woman needs to go through all sorts of procedures and runs the risk of losing custody of her children. Testimony is worth half that of the men. She inherits half to make sure she is financially dependent. And that's the idea that women are responsible for the collective identity within the religious community. So from this thought also the United Nations, the Commission on Women's Rights, said that all member states need to destimulate informal and religious laws, should not accommodate private cultural family laws, and what they certainly meant was not to accommodate. So message to member states, do not accommodate personal family laws. So there is, in fact, a conflict between Islamic and secular principles. Now, for my legal approach, this one was the most interesting one, because Phillips and Williams said it should be possible to choose legal systems. It should be possible to choose jurisdictions. And then I thought, well, what does this mean for the state? What does it mean to choose jurisdictions? So I came up with a list of possibilities for the state, and one is delegation, just simple. You look at a state, you look at the people, and you say, okay, the Jews get that, the Muslims get that, the Catholics get that, atheists get that, just strict separation. I thought that that is highly, highly unlikely in Europe, so this is just a mere theoretic possibility. Second, based on free choice, people can go to their own legal systems and they can deviate from state laws. So based on free choice, you can deviate from state laws. And I also thought that that is not very likely in the United Kingdom. So we get to number 3, the partial dependent accommodation. And this is the one where Williams and Phillips were aiming at. Based on free choice, as long as it's not conflicting with national laws, people are free to use their own religious courts. And that's when I thought, but what does that mean? What does it mean to choose jurisdictions in that sense within the confines of national law? And that's when it occurred to me that this makes no sense at all. Because what do Sharia councils do? They deal with one-party requests, so it's not even a legal decision-making that you have to solve a conflict. It's a request, so you basically just tick the boxes. Where's the husband? Have we contacted her husband? Doesn't respond. Is there violence? Can she prove it? Etc., etc., and you tick a box, and this is what they do. Now, these women go there because they want to get a divorce, so choosing would imply that they could get the same at a civil institution, at a secular institution. So, for instance, let's say I would want to choose between jurisdictions, let's say inheritance, I've got a will, and then I'm thinking, okay, at which institution will I get the best result? So forum shopping. But there is no choosing, because for a civil marriage and a civil divorce, you go to a secular institution. And for a religious divorce, you go to a religious institution. So there are two different products, and there's no overlap. So there's no choosing involved. If you want a religious divorce, you go to a Sharia council. Secular judges cannot do that. So there is nothing to choose. And the state is also not tied to these institutions in any sense. As I said before, there's no occurrence when Sharia law council, well, you can call it a ruling or an award, but it isn't, was ever checked by a secular court. So what you have, in fact, is number 4. There's a toleration of a few dozen Sharia councils in the United Kingdom. They are not accommodated, they are not recognized, there's no legal, there's no law on their existence. There was a debate once, but still that's not a accommodation or recognition in that sense. So there's also no supervision, there's no authority. Because of journalists and activists, we've got a bit of an idea what's going on there, but nobody has a full map on what is going on there. So that has prompted, and that's what I think, for one politician, a member of the House of Lords, to make a law to intervene, and that's when we go to number 5, state intervention. There is also the One Law for All movement, a women's rights organization that that is against these Sharia councils, and together with Mariam, with Pragna Patel, they are trying to get across the message that what happens at these Sharia councils is involuntary and discriminatory. So involuntary would mean that people are like being forced to go there. I don't know if people are being forced to go there, but the circumstances that makes them want to go there are far from chosen freely, and that is very important to state here. The idea is that you want to get a religious divorce not because you want to keep a healthy relationship with your God, but it's because you really run safety risks if you walk around in a community still married, especially abroad. So a Pakistani woman told me that she wanted to get a divorce and she got a civil divorce. She didn't care very much for her religious marriage. She hadn't spoken to her husband in years. But in the eyes of her community, she was still married. And she said, as long as I'm not free, my parents in Pakistan run the risk of getting their house burned down with them still in it. So these are the situations that prompt women to go to Sharia councils. So in that sense, it is very much involuntarily so. In 2012, there was a bill made, and it is now, it has had its first debate, and it was accepted, and it will probably take many more years before this will ever become a real law. But the content is that falsely claiming jurisdiction, so you have to understand that some of these women who go to these Sharia councils are unaware of their legal rights, do not know that they have secular courts where they can go to if there's violence, that if you falsely claim jurisdiction, you get 7 years in jail. And it's difficult to assess what effect that would have on the functioning of Sharia councils, because you can also say that as long as a Qadi says, we are an advisory organ, the government prompts me to tell you that we are an advisory organ, they can still continue what they're doing, except for custody. And that's very interesting, because now they are not in a position formally to grant custody, but in fact they do, because it's often a piece of the bargaining that the husband gets the children and she'll get a divorce, which is obviously a horribly cruel thing to do. But after a few years, and a woman finds out that she was at an illegitimate council, the children have already become accustomed to their father, and then even a secular judge will not grant the women the custody because it will be too big of a change for the children. But with this law, the Qadi, the Islamic judge that illegitimately ruled on the custody, will face jail time, because it is a proof that he was falsely claiming jurisdiction, because if a woman gets told, we are an advisory organ, I'm not allowed to deal with custody issues, then she will probably go see a secular court for custody rulings. But let's say you make these councils illegal if you can. I don't think you can, but let's say, will that solve the problem with regard to marital captivity? For instance, that will make a woman have to go to an imam, for instance, and I do not have much faith in that either. Interestingly enough, the Dutch organization Farm for Freedom has been making laws in the Netherlands to provide secular alternatives for the problems of marital captivity. The president and director of this institution is a Pakistani Dutch woman, and she herself was a victim of marital captivity for years. Her husband refused to grant her a religious divorce, so she went to the civil judge, and he imposed financial penalties for every day he refused to cooperate with the religious divorce, and obviously instantly he did, and she was free. So that is one secular alternative for Sharia courts. If women know that they are not dependent on male-dominated Sharia councils for their religious divorce, one can do it via a tort case, and that is a huge improvement. And the second, what the Farm for Freedom organization managed to do was to broaden the definition of forced marriage to include marital captivity. So it's not just illegal to force a woman into marriage, but also to force her to remain married against her will. So that's when marital captivity became a criminal offense. And interestingly so, about half a year ago, a Jewish woman went to the police and pressed charges based on this offense, and the husband was so intimidated that he immediately released her from marriage. So that is the status quo of Sharia councils in the United Kingdom and some secular alternatives. And I'm very interested to hear what everybody else has to say on it.
Thank you very much. Thank you very much. I would say that both speakers kept the time very properly, very diligently. Before we have a break now of about 15 minutes, I don't want to start a debate, but is there any quick question, just I would say on matters of fact? Something that, yes, please. You need a microphone. So just to make a few things clear, information and...
I would ask a question, because actually legal pluralism in family legislation is already taking place officially and legally in one part of the European Union. And that is due to a 1923, if I'm not mistaken, convention.
Right.
Please?
You're thinking of Greece, right?
Yes, northern Greece, of course. So they have full right, and they have a full right to deal in Sharia courts with family law. And that was based on what you described, actually, in the Ottoman Empire. That's still a custom which is taking place in Europe. So why is it not being discussed more broadly as an alternative? And a second issue was on the second speaker. I think it is right what they do, and what we also try to do in Belgium, is actually stressing the public order aspect in private relationships. Because what you said, we need to criminalize or either to impose tort and negligence. That's a part of negligence of the state, I would say, to protect these women kept against their will in marriage. And that would be a good solution. So, 2 quick remarks.
Very quick, very useful. Yes, if you don't mind, there's another request there. And then, of course, you will give also some quick answers.
Gianluca Parolin, you spoke about 3 combinations, 1 jurisdiction, 1 applicable law, 1 jurisdiction and multiple applicable laws. Is there a room for the 4th combination, multiple jurisdiction, but 1 applicable law? Because this is the case in some fields covered by the law. So is there also multiple jurisdiction, but 1 single applicable law?
Any other quick question? Yes.
Just a clarification from the last speaker. It isn't clear to me why you said that there is no choice in the courts. It is not voluntary, because to my mind, when you decide to have a religious rather than a civil marriage, you are also choosing the court of your wedding, isn't it? Or do I miss some element in this?
Very good. Any other quick question? No, then we can. Who wants to start? You want to start, Gianluca?
So the Greek case is the outcome of possibly one of the worst possible agreements, which was like an mutual ethnic cleansing with the agreement on exchange of populations between the Turks and the Greeks. So they sent back respectively, the Turks in Greece and the Greeks in Turkey. Part of that deal was, as you mentioned, the fact that the Muslims of Western Thrace would maintain their jurisdiction and applicable law. I think that what is interesting in the perspective of the contemporary European arrangement is that Greece decided not to extend this jurisdiction to new Muslim communities in Greece. So they said this jurisdiction works only for Greek citizens of Turkish background who were in that particular area and operate under that system. So it was a decision not to extend that model beyond the historical framework in which it was decided. So yes, it's certainly interesting, but also interesting the decision not to extend it. In terms of multiple jurisdictions, one applicable law, possibly the only thing that I could think of would be to have one civil law that religious courts would apply in a family law. I don't know how amenable that would be. There's clearly a resistance towards one family law. But the fact that you have one family law that is applied by, various judges, I'm not entirely sure how that would work. I don't think it has been entertained as an idea so far.
Since you have the floor, could you just tell us what is your reaction to reference to the Refah Party versus Turkey decision?
Oh, yes.
Because that goes very much to the core of it, but without giving, but just what do you think?
Well, the Refah Partisi, which is one of the many dissolutions of parties, Turkish parties, that was upheld by the court. So I think that's a clear position of the court on legal pluralism, if you wish, right? Besides the quote that Machteld showed us, I believe that besides their assessment of what Sharia is, they were very much against, at least that's how they articulated the reasoning or their argument, is like they were very much against the idea of pluralism. So their problem was not necessarily with the content of the law that was going to be applied, but rather with the fact that you would introduce distinctions among the citizenry on the basis of religious affiliation. So in that sense, I think it's particularly interesting for that. I also think it's interesting that what that kind of jurisprudence of the court, this case law of the court, created in the Turkish political parties, which means that they just pushed the issue of religious courts or religious law, it pushed it under the carpet. So it's not that they disappeared, they just realized that they cannot put it in their statutes. So you run, your political platform without ever mentioning that. But everybody knows that you have some sympathy towards that model. You just don't say it because if you say it, you know that you're going to get dissolved by the court. Well, now with the current court, I don't know if it ever would happen again. But anyway, and that court decision would be upheld at the European level. So that has had an effect to push the debate on the unofficial level. It hasn't disappeared. So I'm all in favor of bringing things to the fore. So if a decision of this of the like, push the things, under the carpet, I'm not entirely sure. It's
Now, let me just elaborate a little further on it. A former professor of Islamic law in this law school, who was here until a few years ago, Abu Musa Ramadan from Israel, wrote an article on the Israel Law Review, which appeared in the Israel Law Review, claiming that this decision showed to be unaware of the fact that Islam is not a monolithic reality, but that within Islam you have a plurality of schools of interpretation, so that you cannot say that Sharia law is inevitably inconsistent with principles of democracy and protection of human rights, which I think is a very important statement, and I would say that this perhaps needs to be explored further, because if there is any chance of developing what is usually known as European Islam, it is from within Islam itself. So from this point of view, I would agree with Abu Musa Ramadan in saying that perhaps the court has tried to make it too simple, and therefore the basic reasoning of the court has been oversimplistic. So is there any scope with that? Yeah?
Well, maybe for later, but I think that yes, that's one of the key issues, because also in Mahdel's presentation, and I think that that's a dilemma within the Muslim community, that is, what is the proper, law? What is the proper Islamic law, right? So the idea that there is one Islamic law that has been set there for, for ages to come, is also it's an oversimplification, as you said, of what Islamic law is, but also doesn't take into consideration that that particular law, which is believed to be there forever, for all ages and for all geographical situations, is actually quite the contrary, is very geographically and time set, which means that usually fiqh treatises cover in a differentiated mode situations in a Muslim majority context, which they do not articulate as Muslim majority, but they articulate it in Muslim-ruled territory, and what happens outside of that. Now, this distinction between Muslim-ruled and non-Muslim-ruled is, of course, challenged, because it's no longer useful as a category, also because the challenges to fiqh itself come mostly from Muslim ruler in the region. So that distinction does not hold water. And on top of that, the extension to non-Muslim ruled territories was not foreseen by the scholars themselves, who clearly had in mind that kind of societal context. The problem of breaking away from that, I think, has to do with the way in which Islamic law has been portrayed, and for once, it's not the fault of the West, but by Muslim scholars themselves in the last couple of centuries. So that somehow essentialized the debate and somehow blocked it. But it's certainly central to see how, what are the directions that will be taken in the future.
Now, this is particularly important, as we have one area, and I thank very much Professor Gracien Lauvers for raising the issue indirectly, in another area, which is the area of education. Now, you could not have state-supervised Islamic schools in the Netherlands or in Belgium if Islam was so inherently not reconcilable with, let's say, a humanistic approach in education. So that's another area to be kept into consideration. Machteld, you want to give a quick answer?
Yes, quick answer. I'd be very interested to hear how Belgium is dealing with the case now. I do not know as much about that as I would like to. So perhaps later today we can talk about that. And with regard to your comment, what I meant with choosing initially was that you have, let me see, that choice requires two jurisdictions dealing with the same matter but with different rules. So that would imply some sort of forum shopping, but now they are two completely separate matters. But your interpretation of that is actually very interesting, and I do not want to comment on it now. I want to let it sink in a bit and see further. Thank you.
Well, thank you very much to both speakers and the audience, of course, and also for all those who did answer quick questions. We have now a 15 minutes break, and I hope to see all of you back here at 11:40. Thank you.